So, Christine, we're going to start back up, and we do have some questions in the room.
Great.
Hi, I just have a question. It's been a long time since I've been involved with ICWA, and one of the things that was told to me was we had a qualified expert witness give testimony. And unfortunately, there were like 5 different fathers in the situation. And so as each father got to cross-examine our qualified expert witness, I guess some of the questions became, too sensitive. So who actually defends the qualified expert witness? Somebody's got to get up and say, I object, to that question. I think expert witnesses, we come from a very culturally oriented community. And we would probably have quite a few qualified expert witnesses if they didn't fear that somebody was going to put them on the witness stand and make them uneasy. I guess that would be the word. Who badgering, yeah. But not being there, I really don't know whether it was badgering. It could have just been as easy as, I don't know. I can't say. I'm just curious as to who is actually supposed to object to some of these questions. Who's on my side as a qualified expert witness that's going to say, I don't think that question is appropriate, or I object, or.
Okay, so did you hear the question, Christine?
Yes, I did. And we're going to cover the actual testimony and being in court and being going through the direct questioning and then also the cross-examination a little bit later. And we're also going to talk about what happens, what are some of the potential outcomes if you're using the ICWA, the tribe's social worker or the tribe's representative on the ICWA case as the expert witness. And one of the things we will talk about is if there's not someone else in the room there on behalf of the tribe and the representative is serving as the expert witness, then the only person that can really object is going to be the person that's on the stand giving the testimony. If the tribe's represented by an attorney, then that person can object to questions. And if the tribe's being represented just by someone other than an attorney, like a social service provider or a tribal council member or some other tribal employee, then it would be that person's duty to object to any questions that they felt were inappropriate, but those questions would need to be inappropriate by a legal standard, so irrelevant, for example. If the questions were being asked only to make the person uncomfortable, then certainly it would be appropriate to object to any line of questioning that wasn't providing any relevant testimony. But I think when we get to this part, we'll talk more about it. Expert witnesses should be prepared to be asked questions that will make some people uncomfortable. And it's one of the challenges in securing a really good qualified expert witness. So we'll talk more about that when we get into what it's like in the courtroom.
The attorney representing the tribe would be the one to protect the qualified expert witness, or if there's a social worker representing the tribe. The long answer is we'll get into that in more detail. And so.
But another part of the short answer is don't forget that they are expert witnesses, and that means something in the law. So an expert witness in court is someone who has expertise above and beyond a lay witness. And experts are not experts in everything. So an Indian expert is not an expert in fuel tanks or in crops or in something that has nothing to do with their expertise. They're not even necessarily going to be the court's expert or a party's expert. They could be one or the other or both. So you have to be careful, and I don't think there's an abundance of precision in these cases. So they're just the expert, and it's not clear if they are the county's expert or the party's expert. The short answer is if it's beyond their expertise and if the question is beyond the documents that they reviewed, it is not relevant because it's not part of their opinion. Every expert in every case, you are allowed to find out everything they relied on, every discussion, every paper, how much they've been paid, everything. And that alone is the basis, that's the foundation for making their opinion. So if someone asks them about something, a deviance or an embarrassment or something that has nothing to do with the opinion that they're giving, it's objectionable by any of the lawyers. I'm not sure courts are that patient though with lay, tribal, audience members. I think it has to be made by a lawyer to do it the legal way, if that makes sense.
So Mark, you and the gentleman sitting next to you actually didn't get to introduce yourselves. Do you mind introducing yourself?
I'll introduce the gentleman next to me. His name is Mark Bizzola, and my name is Mark Radoff, both from California Indian Legal Services. Hi, Christine.
She could tell it was.
Hi, Marks.
So Mark R and Mark B. Okay, cool. Because we can't even, you're both from CILS. Not to complicate matters, right? But you're both sitting down. Ah, got it. All right, thank you, Marks. And Mark R. Thank you. So, Christine, did you want to add anything to that?
No, like I said, I think we're going to cover that more at a later point.
Okay. Are there any other questions in the room? Okay, with that, let's move on to the written declarations.
Okay, great. So we left off here at using written declarations, and a little bit of the history behind why this slide even exists. Some social services departments had gotten into the practice of using written declarations of a qualified expert witness in court instead of having someone present and giving live testimony in the courtroom. And for those of us who were in court on behalf of tribes at the time, it was very challenging to have only a written declaration because you cannot cross-examine a written declaration. And so if there was something that one of the parties, and in my case, I was always representing the tribe, so if there was something that, for example, the tribe didn't agree with in the declaration, it was difficult to try to challenge that because there was no live person there to give a response as to why that was included in their declaration and what qualified that person to make that statement in their declaration. How did they get that information? What were their expertise? So after enough challenges, I think, were made when CalICWA was passed, we got our clarification in that law, and this is California law specifically, because the Indian Child Welfare Act itself, it's silent as to whether or not the testimony must be live. In my opinion, and again, we've talked a little bit about bias, and we all have bias. I think testimony means live unless it states otherwise. But like I said, in California, we were having a problem with this. So now we have it very clear and expressed in California law that qualified expert witness testimony must be live. So you have to have an actual person in court giving the testimony and be there to be cross-examined and show their qualifications to all the parties. Unless there are exceptions, all of the parties can reach an agreement or a stipulation, which is just a legal term for a written agreement, basically. So an agreement in writing that everyone is going to agree to have this written declaration instead of live qualified expert witness testimony. And the court must then find that this agreement or stipulation was made knowingly, intelligently, and voluntarily. So I always tell anyone that has the burden of providing a qualified expert witness that you should prepare to have a live person present in court, because reaching an agreement between all the parties can often be difficult. And for any of you that have worked on any cases involving child welfare, whether it's Indian child welfare cases or not, we've got mother, father, potentially the Indian custodian, we've got the child's representation, and then possibly the tribe. And so that's a lot of different people that all need to agree in writing that they are fine with this written declaration versus live testimony. So I think it was a really great improvement to the law to get this clarification, because I'm not seeing the declarations being misused as much as they were. But just, keep in mind that it should be live testimony unless you have this written agreement. Okay, I wanted to now touch on active efforts, and I know that this is not an active efforts training. This is a training on qualified expert witnesses, but I wanted to discuss what were the standards for showing active efforts have been made in a case, and is there a way that qualified expert witnesses can be used to meet these standards? So again, we've got some very specific legal citation here. It's 25 USC 1912, which is the Indian Child Welfare Act itself, and the section pertaining to pending court proceedings. And then in section D, we've got remedial services and rehabilitative programs, preventative measures. And I wanted to put this quote in because I do feel like there's some confusion around qualified expert witnesses and active efforts and how those two things work together in cases. So what is required for these remedial services and rehabilitative programs? Any party seeking foster care placement or termination of parental rights shall satisfy to the court that active efforts have been made to provide remedial services and rehabilitative programs designed to prevent the breakup of the Indian family, and that these efforts have proved unsuccessful. So that's the federal standard. A party seeking foster care placement or termination of parental rights has to satisfy to the court that active efforts have been made. Moving on, we've got the Welfare and Institutions Code, section 361.7, and that's pertaining to termination of parental rights of involuntary placement of an Indian child with of a child with Indian ancestry, and we're talking about the standards again. So under the Welfare and Institutions Code, which is our California law, parties seeking involuntary placement, involuntary placement or termination of parental rights over an Indian child shall provide evidence that active efforts have been made. So we've got evidence now. The standard is evidence that active efforts have been made. And then the California rules of court back up what's already been said in the California code and in the federal code. To place with anyone other than the parent or Indian custodian or terminate parental rights, the court must find that active efforts have been made. So we've got the court having this obligation to make a finding that active efforts have been made, and we know that we need to provide evidence that active efforts have been made, and basically the court needs to be satisfied that active efforts have been made. So why am I talking about this? Because I want to clarify what the qualified expert witness testimony can do here. So you'll notice that qualified expert witness testimony isn't specifically required to show that active efforts have been made. There needs to be evidence, and the court needs to be satisfied that active efforts were made, but there isn't that burden of proof that involves the qualified expert witness, the way that we see it really expressly required for placing the child in foster care or terminating parental rights. So with that said, you certainly can use a qualified expert witness to show that active efforts have or have not been made. It's an option, and it's especially useful in establishing if the active efforts were culturally appropriate. So you can use the testimony of an expert witness to establish what are the tribe's cultural practices, what are the tribe's child rearing practices, and cultural norms around Indian children and families. So I think that there's some confusion over what's required of the qualified expert witness and what is best practice. I think best practice would be use that qualified expert witness to testify whether or not culturally appropriate active efforts have been provided to the family. But is it specifically required in order for the court to make the finding that active efforts have been made? No, qualified expert witness testimony is not required for the court to make that finding. But the court should have some evidence and some proof that active efforts have been made. So I hope that that is clarifying and not making it more confusing. But this is just another area that I see, I've seen in some courts getting confused about when the active effort or when the qualified expert witness is required versus when it's best practice to have an active qualified expert witness. So we're going to move on and do a review quiz. And this is going to be for just what we've covered up to this point in the presentation. And we're going to take some time now and let all of you in the audience answer these questions on your own.
So just take 10 minutes now to look at those questions and kind of think through them and write down what your responses are. And then we'll go through all of the questions and the answers as a group with Christine kind of walking us through the best answer. And then if your answer didn't fit the best answer, we could talk about why, or if you feel that maybe your answer is better, we'll have some discussion with Christine on that.
I can either go over the answers or we could go through each question and see if someone in the audience wants to answer it.
All right, let's check the audience. Does anyone want to answer number 1? Any volunteers? Bueller? Oh, awesome. And you guys got my Bueller reference. Hold on, here we go.
Of course. I'm just going to repeat the question so we know which question we're on. The Indian Child Welfare Act was passed in 1978. Why is the Indian Child Welfare Act still needed today?
My answer is because there still is an overrepresentation of Indian children in the child welfare system.
Yes, that is correct. Because there's still an overrepresentation of Native American children in the child welfare system, and because that could demonstrate that there is still cultural bias and institutional bias that is present in the child welfare system. There are other reasons as well, but for our purposes, we are looking at that qualified expert witness testimony. So thank you. That is exactly the answer I was thinking of. Okay, the next question is, why is a qualified expert witness needed in ICWA cases? So anyone want to try to answer that one?
To determine by the standards of that child's tribe that return of the child to their home would result in serious physical or emotional damage.
That's exactly right. All right, we are batting 1,000. I love it. Okay, so the next question.
Christine, let's see, did anybody have different answers than those answers for the first 2? It's okay if you had a different one.
Oh, yes.
Oh, we had a different one. Hold on, it's going to take a moment. Let's get you mic'd, Mark. Right.
Which Mark?
The Mark Radoff. I had 2, for number 1, I had 2 different answers. Number 1 was cultural bias.
I'm sorry, I can't hear Mark.
Cultural bias. The states have elevated non-Indian homes for placements above tribal placements. The second, actually there's 3 parts. The other part is to facilitate tribal court development for transfer of Indian child welfare cases to tribal courts. And third is because it's the federal law, and even though it was passed in 1978, you can't just pick and choose which federal laws you want to apply. So it's still the law and it still applies.
I'm sure that was great. I couldn't hear most of it, but
I will attest that everything Mark said was accurate. You'll like the fact that it's still law today, and you can't pick and choose which federal laws you want to follow. That was my
That's right.
favorite of Mark's responses. Are there any other questions or answers different than the first two? All right, let's do number 3.
Okay, when is the testimony of a qualified expert witness required?
At disposition before a removal finding. So it's a prerequisite for before removal, the detriment finding is.
Did you hear that answer, Christine?
At disposition before removal finding.
Yes, was that accurate for our purposes?
I'm sorry, Stephanie, what was?
I just want to, I'm going to say yes, that was accurate for our purposes. We have another answer too, a different answer that was offered.
Okay, well, let's get all the answers and then we'll talk about all of them.
I just answered in cases where there's foster care placement, termination of parental rights, and then when they, I think that was it, there was 3 of them. Deviation from placement preferences.
Were there
Okay.
any other different answers than those? So the last one was, I'm going to read over your shoulder. In cases of foster care placements, termination of parental rights, or deviation from placement preferences. Okay, so that was all of the answers we got here. Back to you, Christine.
Okay, so the second answer is exactly what we covered this morning, that the court is required to have a qualified expert witness testify before they can order foster care placement or termination of parental rights. And then also in the instance when the court's going to find that there was good cause to deviate from the placement preferences because of emotional or extraordinary emotional or physical needs of the child. As to the first answer about the removal, I'm not sure that there's direct legal authority for that. It depends on if at removal the placement is actually being made. And in California, the court does not consider that the child is actually being placed out of home legally until the disposition hearing. And a lot of times the disposition hearings in California are combined with jurisdiction. So you'll hear the term the jurisdiction disposition hearing or juris dispo. So legally, it's really not until that point that the child's being placed out of home, even though physically the child is removed and placed in what is basically an emergency placement at the very beginning of most cases. So I would say that you could definitely argue that the child's being physically placed at removal, but in terms of the legal standard, the placement actually occurs at disposition in California. So that's where, at a minimum, we should definitely have qualified expert witness testimony. And then in every case, when termination of parental rights is happening, always qualified expert witness testimony.
Yeah, we have some questions.
Are there any other questions about number 3?
Yeah, we have some questions on, I think, that last clarification.
Okay.
I just wanted to comment on that. As the county, we go out and we investigate allegations of abuse and neglect. If those allegations are substantiated and a child needs to be removed from their home, we do remove the child on an emergency basis. They are detained in a placement. We don't actually place them. We have a detention hearing. The juris and dispo hearings are not set out until 3 weeks after the initial removal. At that jurisdictional hearing, we would take jurisdiction, but before we could get a dispositional finding, we would have to have expert witness testimony. So I just wanted to clarify how things move along in the system.
The county can and does make removals that were they become the de facto placement because the milestones are never made. So the 10 days or the 15 days for setting a hearing and having a hearing, even though the code requires a separate hearing for jurisdiction and dispo, they've been combined. So the dilemma is, the removal issue is, if you read what the language says, the removal is what triggers it. It happens when the finding is made at disposition. But the danger is if you wait 3 months into a case after a placement has become stabilized, everyone argues that you're upsetting the apple cart, that there's been a measure of stability, and that's the problem. So the county would take it one way, but as an attorney, I would argue at the earliest possible stage that you can't let the emergency findings become the permanent de facto findings.
So we're getting a little bit of a, you'll see how this concept of removal versus disposition, we're getting into very legal terms, and I want to acknowledge that because we don't have a lot of folks that are necessarily lawyers here today. And actually, thank you for the qualification on the timeline. So what we're dealing with the qualified expert witness, and Christine, jump in if I get it off, but I'm just kind of going with what we've heard. What we're dealing with the qualified expert witness is the triggering legally, and whether that's appropriate or in the best interest of the Indian child is up for discussion. But legally, the qualified expert witness is required when you have a legal proceeding to determine where the child's going to be placed in foster care placement or if the termination of the parent's rights. However, as was pointed out, in situations where the county's called or maybe the tribe's called, someone's called because there is a report of abuse or neglect, someone goes in, they see evidence, the caseworker sees evidence that the child needs to be removed from the home, and they're detained or placed in a placement temporarily as an emergency placement. That is not under the law considered when you need a qualified expert witness. The thought process is, we don't have time to have a trial and get a qualified expert witness. The child's in harm, so we're going to detain them temporarily until we can have that hearing. And as what Mark's pointed out, under the law, that hearing where the qualified expert witness is triggered is supposed to happen, a certain couple of weeks, 3 weeks. It may take longer before you actually have that hearing for jurisdiction or have the hearing where you determine the temporary placement into foster care or the final removal. And so the child is sitting there in the temporary emergency placement. They've been de facto, for all intents and purposes, removed from the home, and there hasn't actually been that legal trigger of the expert witness. So I think, Mark, maybe what you were pointing out is the cases need to happen sooner where we have that legal trigger of the expert witness, because the time the child's outside of the home becomes evidence against placement within the parameters of ICWA. Is that fairly consistent summary of what we've heard for those that made comments? Okay, so for those of you that aren't legal, do you understand that legally the qualified expert witness is triggered in those hearings for temporary placement of foster care or termination of parental rights? But for all intents and purposes, when you're in the field, the children need to be removed for other purposes, and you won't necessarily trigger that qualified expert witness. Does that make sense? I know it might not make sense, but do you kind of understand where this gets triggered and why you might not see a qualified expert witness during a temporary removal for emergency? So there's emergency removal, and then there's temporary placement for foster care. Anything you want to add to that, Christine?
No, I think just, whether it should happen at detention or not, the requirement for a qualified expert witness legally kicks in when the court is making findings that we're going to place in foster care. And so at the detention hearing, it's not officially a foster care placement at that point, even though for all practical intents and purposes, this child is being placed out of the home. So it's just one of those areas of law that is a bit inconsistent with what's going on in the court and what's going on in the child's life. And so all I can say is that, we, if need be, then collectively as a community, we need to make sure that courts aren't considering that what's going on in that period before the disposition as evidence against the family in court. And I know that's a challenge, but my job here today is to talk to you about the legal requirements of the qualified expert witness. And legally, it kicks in at foster care placement, which in California officially happens at disposition.
So let's go
Is there
to
anything else on 1, 2, or 3?
1, 2, or 3. Do we have any other questions, comments, clarifications? Okay. Number 4, Christine?
Okay, what must the qualified expert witness testify to in order for the court to order an out-of-home placement or termination of parental rights? That should be plural, parental rights. And I'm looking for the exact testimony, and we covered that language.
Does anybody want to take a stab at this answer?
Specifically, that continued custody by the parent or Indian custodian is likely to result in serious emotional and physical damage based on the tribe's social or cultural standards.
Excellent. Is there anyone who had a different answer than that? Okay, those are all the answers. Christine?
Okay, that's exactly correct. Great job. And I think it's really important that if nothing else, everyone in the room takes away that specific language, because if that language isn't in the court's findings, then really the removals could be challenged, the placements can be challenged, and the termination of parental rights can be challenged. That is the required testimony that needs to be in the court record. So I'm glad it seems like we all got the exact language. That's great. We'll move on to number 5. Does the testimony have to be live?
I put yes, unless agreed upon by all parties.
Anyone else with anything different or more? Okay, so we got a couple folks saying agreed to in writing. So those are the answers we've gotten here. Christine?
Yes, those two together are exactly right. The testimony does have to be live, so that would be our default position, yes, live testimony. However, there is an exception. You can use a written declaration instead of live testimony, but only if all the parties agree in writing. And that, for those of you who aren't lawyers, is often referred to as a stipulation. It's a written agreement that the court is going to review and either accept or deny. So all the parties agree in writing or live testimony. And I think live testimony is always preferable, just because it's a more dynamic and you probably get more and better information.
And Christine, I just wanted to reiterate, you mentioned it before. Now, the live testimony legal requirement is in California. And for those of you that are from states outside of California, it will depend on what your state laws are. The legal requirement we're talking about today is pursuant to California law. But it doesn't mean that your state might not have a similar law that requires live testimony. At any rate, it is a best practice if you're not in California. It is a legal requirement if you're in California. It is a best practice out of California.
Yes, and I would just add to that like I said, until I was working in Indian Child Welfare Act cases, it never occurred to me that testimony could be anything other than live. I've always felt like, testimony, especially you have a qualified expert witness, it just never occurred to me to have that be in a written form. And it was happening quite often in California. So I think this is a California specific one, but it just, in my opinion, and I know we've got a couple other lawyers at least out there in the audience, I would say if you're outside of California, most often than not, live testimony is what's going to be required for a qualified expert witness. I can't think of another case where an expert's been used for some other purpose and they've been allowed to just submit a declaration. They usually need to be present in court. So that would just be my qualifiers. This is, it's more of a clarification in California because we were having some, let's say, confusion.
We're all set if you want to go with the next set of questions.
Okay. So the next question, and this is one you don't all have in front of you, what is institutional bias? Does anyone want to take a stab at sort of defining for us what is institutional bias?
I think I'm going to try to paraphrase this instead of come up with an actual statement. So paraphrasing, I would say it is the idea of the ruling community that a situation should take place or that prevailing thoughts should take place.
Okay, so great answer. That is correct. I'll just repeat, and this is from the presentation earlier. Institutional bias is to give official sanction to applying a prejudiced outlook to something, i.e. Indian families in our cases. So anytime we've got an official sanction that's applying this prejudiced outlook, that's going to be institutional bias. And certainly Indian children and families have not been the only ones to experience this institutional bias. But for our purposes for ICWA, it's really what kind of spurred ICWA being passed in the first place was the institutionalized view that Indian children were better off being placed outside of their communities. So that was the bias. While we're on this subject, can anyone think of some other event in California history that might be an expression of institutional bias? Just as a bonus question, Stephanie will give you an extra cup of coffee.
I will hand deliver it. I actually heard someone. Do you want to do it, or do you want me to say it? I heard what you said.
I said boarding schools.
So the from next to me, I'm mic'd better than she is. Boarding schools was one example that was provided. Can anybody think of anything else?
My guess is going to be same-sex marriage.
Okay, so we have same-sex marriage as another example of an institutional bias. So we're not just talking institutional bias from California Indian families or Indian families. We're talking any other example of institutional bias in California. All right, we're gonna send it over to you now, Christine. What are your thoughts on the answers? Boarding schools and same-sex marriage.
I think those both reflect institutional bias. Boarding schools was definitely the federal policy that Native American children should be removed from their communities for quote unquote education by schools run by missionaries. And so that is definitely an example of institutional bias. And I think whether a state chooses to support or not support same-sex marriage is an example of institutional bias because it's a law and it's going to be reflecting the institutionalized opinion around a certain issue. For that issue, it would be same-sex marriage. Is it good or is it bad? So I think those are both good examples of institutional bias.
Excellent.
Okay, we've got another question. What is the burden of proof for foster care placements? And I know the marks know this one. So is there any non-attorney that wants to try to answer? What is the burden of proof for foster care placements? And this is involving Indian children. So for the court to order foster care in an Indian Child Welfare Act case, what is the burden of proof?
Do we have anyone who wants to take a stab at that answer other than the marks? Because we know you know.
We do, we know you know.
If you want to offer, if nobody else has an answer, then you are welcome to. Anyone other than the marks want to offer an answer? The burden of proof for foster care placements. I feel like a quiz show host. And Margaret is my Vanna. I wish. Marks, do you want to provide it since we have no other takers? So what is the level of the burden of proof required for foster care placements?
Is it clear and convincing, Alex? Beyond a reasonable
Very
doubt.
good.
See, the other side knew. It's either
Oh.
beyond a reasonable doubt or clear and
It
convincing.
is.
Nice. We actually, you couldn't see it here, Christine, but Mark's offered one response, beyond a reasonable doubt, and then it was across the room that someone said, no, it's clear and convincing.
Very good. So for foster care placements, it is in fact clear and convincing evidence and the testimony of a qualified expert witness. So where it would only be clear and convincing evidence in other cases, for ICWA cases, you have to have the testimony of a qualified expert witness. Now, we've got the burden of proof for termination of parental rights. And someone's already touched on this, so.
The answer's out there. Does anyone want to take it?
Evidence beyond a reasonable doubt, which, as I talked about earlier, is a higher standard than clear and convincing evidence. So for termination of parental rights, we have a higher standard, which is appropriate because we're talking about a very final order that's going to, affect parental rights forever. And then, of course, qualified expert witness testimony is also required. Okay, next question. What are the sources of law for ICWA, qualified expert witness requirements? And you don't have to cite each little citation, just the names of the sources generally is all I'm looking for.
So when you're looking to figure out what the qualified expert witness requirements are and you need to do your research, where are the sources that you would go to for the qualified expert witness requirements? I see some head shaking. Anybody have any ideas or responses they want to offer? This is a pilot test. I think next time I might need to offer candy for those that provide answers. Oh, we've got a taker.
I'm going to say 25 USC.
25 USC, so the US code.
1912.
Nice.
E.
There it is.
I will point out that our volunteer did access the PowerPoint handout, which is great because you now know where to look for the answer in your materials.
That's right. So yes, that is exactly right. The Indian Child Welfare Act at 25 USC, and then specifically section 1912 E and F. So the Indian Child Welfare Act is always going to be your first source when you have a question on the Indian Child Welfare Act. Go to the source. Anyone else remember anything else that we can look to?
Where you can look to for guidance? Oh, Marks?
CalICWA, SB 678.
Oh, you guys missed it. Christine said we're moving past the SB 678 since there's other references. So CalICWA or WIC was what we were offered by the Marks. And then you had another one?
Well, this is the rules of court. The
Rules of
California
court.
Rules of Court.
California Rules of Court. So what we got here is California Rules of Court and California ICWA or WIC.
Excellent. Is there anything else?
We have silence from the room, Christine.
Okay, the federal guidelines. So the Bureau of Indian Affairs guidelines for state courts, Indian child custody proceedings. Those are actually a lot of what's in the federal guidelines is incorporated in California law and California Rules of Court. And you were all right. CalICWA, specifically for expert witness, that's going to be Welfare and Institutions Code 224.6 and 361.7. And then California Rules of Court. And again, for the Indian Child Welfare Act Qualified Expert Witness Requirements. It's Rule 5.484 and 5.485. So very good. ICWA, federal guidelines or BIA guidelines, CalICWA, and the California Rules of Court. So good job, everyone who got those. And then for you attorneys out there, there's also case law, but I won't confuse everyone too much. Okay, so I think this is the last question. What does overrepresentation mean? What is the term overrepresentation? What does that mean?
Is anybody else hearing the Jeopardy sound in their head? Dun, 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 dun. Okay, we've got one possible response.
Does it mean being in the system?
Okay, so the one response is being in the system as what overrepresentation means. Do we have another thought? Having too many lawyers was another response we heard.
My goodness.
That was from the other lawyers in the room. Oh,
That's a
we
good
got
one.
disproportionality was another suggestion. So we're now just yelling out responses. Margaret can't even keep up with us.
Well, let's just get to the answer in that case. I don't need chaos. Okay, overrepresentation is also another word for disproportionality is often used when someone's disproportionately represented, so overrepresentation. It's when a population is represented at a higher rate in the child welfare system than they are in the general population. And of course, that can be, represented at a higher rate in any system or any context than they are in the general population. And so that is often referred to as disproportionality or being disproportionately represented. And then also it can be referred to as a disparity. So disparity by ethnicity is how California tracks that in some of their data. I think, though, definitely you can be overrepresented by attorneys. That is a problem as well. So, but for our purposes, yes, it means, and the two populations in California that are overrepresented are Native American and African American. And currently those are the only two populations that are overrepresented at a statewide level in the child welfare system. Any other questions on overrepresentation?
I do.
Disparity
Mark, can I use your joke about too many attorneys in the future? All right, I have permission to use that one. Do you have any real questions other than me goofing off? All right.